From almost the first day of law school, students learn that the elements of a common law contract are an offer, acceptance, and consideration. So one would think that experienced lawyers working on high-priced transactions would properly apply that principle to their deal. Sometimes, though, they don't. In Houston Dairy versus John Hancock Mutual Life Insurance Company, an experienced financial actor and its lawyers fumbled the basic concept of offer and acceptance. Houston Dairy applied for a loan from Hancock. On December 30th, Hancock mailed a commitment letter to Houston Dairy, agreeing to lend $800,000 at 9.25% interest if Houston Dairy returned the signed acceptance and a check for $16,000 to Hancock within 7 days. The commitment letter described the $16,000 as a good faith deposit. If Houston Dairy defaulted, that amount would represent reasonable liquidated damages, so Hancock would keep the deposit. 18 days later, on January 17th, Houston Dairy executed the commitment and returned it, along with a $16,000 cashier's check. Hancock received the letter on January 23rd and deposited the check. Hancock didn't communicate acceptance of the commitment, but attorneys for Houston Dairy and Hancock began to arrange for the closing on the loan. Then, on January 30th, Houston Dairy obtained a loan from a state bank at 9% interest. Houston Dairy then requested a refund of its $16,000 deposit. Hancock refused. Houston Dairy sued Hancock in federal court, seeking the deposit's return. The district court held that the parties entered into a valid contract and thus found for Hancock. Houston Dairy appealed to the Fifth Circuit.